The U.S. Supreme Court has declined to hear a case that could have reshaped how artificial intelligence fits into U.S. copyright law. And I also want to say thanks for watching Midwest Agenda Art News. Please hit the like and subscribe. But now, on Monday, the court turned away an appeal from Missouri computer scientist Stephen Thaler, who sought copyright protection for an artwork created by his AI system known as Dabis. The piece, titled A Recent Entrance to Paradise, pictured behind me, right there it is, was submitted for federal copyright registration in 2018. The U.S. Copyright Office rejected the application in 2022, stating that copyright law requires a human author. Lower courts agreed, and in 23, a federal judge ruled that human authorship is, quote, a bedrock requirement of copyright. In 2025, the U.S. Court of Appeals for the D.C. Circuit also upheld that decision. And by refusing to take the case, the Supreme Court leaves that interpretation in place. Under current U.S. law, works created entirely by AI without human involvement cannot be copyrighted. The Trump administration has urged the court not to hear the case, arguing that multiple provisions of the Copyright Act make clear that an author refers to a human and not a machine. The decision, however, does not settle every AI copyright question. The Copyright Office has also rejected some applications involving AI-generated images with tools like Midjourney, particularly when applicants could not demonstrate sufficient human creative control. But those cases differed from Thaler's because he argued that his AI work was created independently. For now, it reinforces a key legal boundary. Only human-created works qualify for copyright protection. That strengthens arguments from artists and advocates who say original human expression must remain central to copyright law, especially as generative AI systems are trained on massive data sets that can include copyrighted works. The ruling, however, does not directly address the separate and ongoing legal battles over whether AI companies can use artists' work to train machine learning systems without permission. Those cases are still working their way through the courts. And I wonder now, if the Supreme Court had decided to hear the case, would this have been an opportunity to illuminate these legal issues? So, the Supreme Court's refusal keeps the human authorship requirement intact. It limits copyright claims for fully AI-generated works, maintains a legal framework that prioritizes human creators, at least for now, in the rapidly evolving fight over AI and artistic ownership. You can read the full story at MidwestAgenda.com, and if you have art news, an event, or project listing you'd like to share, submit a listing right at the top of the page. Go ahead and send us yours. Art in the Midwest matters, and so do you. Have a great day. Thanks. Bye.